I think we're gonna need the name of a potential bio dad.
Do you have the identity of the potential biological father?
Devon Carmucci.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to enforce judgment of divorce. Ms. McNiff, you can proceed.
Your Honor, this is a pretty simple, straightforward case. The parties agreed in their judgment of divorce that they would equally divide all of the college expenses for their children. Their oldest child, who is still 18, mom has now expended $7,987.55 on her college education for this year. Mom will be paying $2,578.33 each month going forward. She's already paid the October payment. Dad has not contributed. Mom has sent numerous emails to Dad asking him to contribute that portion that he's responsible for pursuant to the judgment of divorce without any effect. And we're simply asking that the court enforce the judgment and require Dad to uphold his end of the judgment of divorce agreement.
Okay. Sir, what's your response?
Sure. I can I have I wanted to ask for an adjournment. I just got the letter on Tuesday this past week, and I've been trying to get a lawyer. I'd like to hire an attorney to help represent me in this and speak about my legal rights.
Okay. What the court will do, the court will adjourn the matter 1 week. It'll be set for next week, the 28th at 9 o'clock. So you'll need to have your attorney present at that time, sir.
Is this something that could potentially go to mediation? I think
No.
there's some
No.
prior to my daughter going to college, I tried to meet with Mandy and my daughter about this. Basically, my daughter, I'm supposed to have joint custody, and for the last...
Okay, sir, hold on. You want adjournment. Don't argue the case. If you want an adjournment, it will come in with counsel then next week.
Yeah, okay, that's fine.
Okay, court will adjourn the matter 1 week.
Thank you, Your Honor. Do you want me to renotice that,
Thank you.
or will we just show up?
No, you can just show up. We'll set it. This matter comes before the court on the plaintiff's amended motion for an in-person trial in this case. Ms. Osborne, as I read through your motion, you said that you do suffer from anxiety and PTSD.
Yes, sir.
If that's the case, wouldn't it be more comforting for you if you didn't have to appear in the courtroom with the defendant?
No, Your Honor, because the PPO hearing was a complete flop. I cannot express myself well enough when I hear his voice.
Okay, well, I don't need to get into that now. I mean, the court will allow you to appear in person if you wish to do so.
Please.
I would state, however, so you know that the defendant is not required to appear in person. He can appear by Zoom pursuant to Michigan Court Rule 2.407(b)(4). So you
Yes.
can appear, but that you can't compel him to appear.
That's okay.
Okay,
Thank you, Your Honor.
okay, we'll do that, and we'll make sure we'll set it for an in-person hearing.
Okay, thank you.
Okay, you're free to go. Have a good day.
Thank you, you too.
Court will note the appearance of Mr. Midgordon on behalf of the plaintiff. This matter is before the court on the defendant's motion to set aside referee recommended order. Mr. Lane, you can go ahead.
Yeah, so the last court date was on September 24th. I was not notified of that because the court sent the paper, but it got sent back. So I had no idea this was going on or what was happening. And the front of the court has all that information. Also, I would like to be in the child's life more. I would like to go week on, week off.
Okay,
To also get rid of child support.
okay. Well, if you're gonna do that, you're gonna have to file a motion, sir.
Yes, I did file a motion.
Okay. Mr. Midgordon, what's your response?
Yes, Your Honor, my response is that the defendant attended the previous hearing in July to the best of my knowledge, and upon reviewing the file, I don't know why he would have not received a notice of hearing. I mean, his objection is just that he doesn't like what the court said and he doesn't want to pay child support. I don't think that's a sufficient basis. He doesn't allege that the referee didn't conduct an evidentiary hearing, which the referee clearly did. He followed the law. He made a finding it's the best interest factors whenever he changed custody and parenting time, and the defendant doesn't even allege that wasn't done. So at this time, I think the court should adopt the referee recommendation in order and require that the defendant file some other motion to change custody and parenting time instead of trying to use this as a hearing to change custody and parenting time.
Okay. Well, what the court's going to do, the court has reviewed the file. The court notes that the front of the court did have, again, the correct address, and all the paperwork that had been sent from the front of the court the defendant received. However, the motion regarding custody filed by the plaintiff did not have the apartment number, nor did it have the zip code on the notice in this particular case. So it does appear that the defendant did not receive adequate notice of that particular hearing. So what I'm going to do is I am going to grant the motion and refer the matter back to the referee for additional hearing in this matter, as the court does not believe that the notice was proper. So that's what we will do. We'll get that order out, and you should be contacted by the front of the court within a week or so.
And Your Honor, is that order still in effect pending the next hearing with the referee?
Well, it's in effect until the referee changes it, yes.
Okay, thank you, Your Honor.
Have a good day. Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's motion to revoke affidavit of parentage. In this matter, Mr. Carmucci, you'd stated that obviously you want to revoke that and that you wanted to do a DNA test as well. Is that correct?
Yes, it is.
Okay. Ms. McClann, you have any opposition to the motion?
No. It's to revoke child support and do the DNA testing, or just the DNA test?
Well, it'd be a DNA test, but we would proceed on, once we get that, we'd proceed on the motion to revoke affidavit of parentage.
Oh, okay, yeah.
Acknowledgement of parent.
Yeah, I'm in agreement.
Okay. Mr. Magnuson, is there any opposition by front of the court?
No.
Okay. I'll ask that the parties would get in contact with Mr. Magnuson to make arrangements so that the DNA testing can occur in this case. And once we have that, then we'll be able to set the final hearing. Okay, anything else, Mr. Carmucci?
No, sir. Thank you so much.
Anything else, Ms. McClann?
No.
Mr. Magnuson?
Just to let everybody know, as long as we have a 4D case, which we do in this circumstance, and a known biological father that we can contact and a court order, which I'm assuming will be coming, we can do the genetic testing under those circumstances. So I think we're going to need the name of a potential biodad.
Okay. Ms. McClann, do you have the identity of the potential biological father?
Devon Carmucci?
Oh, okay.
Yeah.
There's
Well-
nobody else to list, so no.
Okay, well, we'll do the testing on Mr. Carmucci then. Do we have an order in the file on this for testing?
We do not.
Okay. Mr. Magnuson, could you assist in that? We don't have an order for the testing and all that. Could you get that and send it to court?
Yes, sir.
Okay, thank you. You're free to go. Have a good day, and you'll be contacted with a time from Mr. Magnuson to do the testing. Court will note the appearance of Mr. Magnuson on behalf of the front of the court. In this case, the court notes the matters before the court on the plaintiff's motion to determine child born out of wedlock and for an extension of time to file the revocation of paternity action in this matter. Ms. Crutcher, when I looked at the motion, you've alleged, obviously in this case, you've missed you've missed the limitation or statute of limitations on this by a substantial amount of time. The child is now 12 in this matter. You had 3 years to file that. You did allege, you said I was prevented from filing because not knowing I was supposed to. You also alleged a one word, you said misconduct, but you did not allege any misconduct. What did you mean by that?
I did not know what to put on there.
Okay. Okay. So why do you believe that the court should, again, make this determination now after the 3 years is not just passed, but long forgotten, let's say?
Because David's not their father.
Okay. Mr. Magnuson, anything you have to add?
I don't know that there's been ample reason giving, especially considering the amount of time that's gone by for the court to grant the motion, but I'll obviously defer to the court.
Okay. Well, in this particular matter, the court does note that, again, a person stating, well, I was prevented because I didn't know I was supposed to file. Well, that's not a sufficient proper cause in these particular matters. And the court is very lenient in allowing, if somebody has missed the deadline by a short period of time, but unfortunately, the statute in this provides that the action has to be brought within 3 years. The child's now 12 years old. The court doesn't believe that the matter is timely, so the court will deny your motion in this matter, ma'am, and we'll get that entered. So you're free to go. Have a good day. This is plaintiff's motion for temporary custody. Attorney time is so Ms. McNiff.
Your Honor, it's my understanding that Mr. Scobie was hospitalized this weekend and he remains hospitalized. We don't know if he has the ability to get onto Zoom or is in any condition to get on Zoom at this point. I don't have any objection to adjourning for a week to see where he is. However, in the meantime, I don't know if the court would be inclined to enter an interim order. Clearly, Mr. Scobie can't care for the party's child while he's in the hospital.
Well, I'm not going to do an order for adjourning it. We'll adjourn it 1 week and address everything next week.
It looks like we're just going to have a lot of hearings next week, Your Honor.
We probably will.
Thank you.
This matter is before the court on the plaintiff's motion to amend judgment of divorce for name change. Ms. McNiff.
Your Honor, we did not put a provision in the original judgment of divorce that would allow Ms. Edwards to change her name back to her maiden name. So we're asking to modify the judgment of divorce just for the purpose of modifying her name back to her maiden name.
Ms. Edwards, in this matter, you sought to change your name in this case. Let me ask you, since the entry of the judgment of divorce, have you received any criminal convictions?
No, sir.
That's all I needed to know, and you're probably wondering why that's an odd question, but what happens when a person's filing to do a name change, that there is a legal presumption that if they've had a criminal conviction, that they're doing it for a fraudulent purpose. So I just have to establish on the record that you're not doing it for that reason. Court will have no problem, then the court will grant the motion changing your name from Brooke Lindsay Howington in this matter. And did you do an order, Ms. McNiff, or are you going to submit that?
We submitted one, Your Honor.
Okay, we'll get that entered then, and as soon as we're done with this hearing, I should be able to get that completed.
Great.
Okay,
Thank you, Judge.
Ms. Howington, good. Have a good day, and you're going to have to get a certified copy of those orders. Take it to Social Security, Secretary of State, wherever you need to change your name.